Thank you. I wanted to get started with a session on state of affairs and class action, which also include an update on Volkswagen potential consequence committee and other cases that are happening both here in the U.S. and around the world. I think everyone here is familiar with the basics of the class action filing in the United States. We wanted to start with some of the key differences between a case that is initiated here and one that is happening outside of the United States. So first, I'd just like to give a brief introduction. My name is Kevin Doyle. I'm the Global Head of Marketing at Batea Class Action Services. And I'm joined today by both David Abel from U.S. Market Advisors and Adam Flo. Gentlemen, if you want to introduce yourselves.
Sure. Hey everyone, thanks for hanging out. I appreciate you sticking it out this long. It's been a long day. I got here at 7:30. I think I was the third person. Appreciate that continental breakfast. So I am the managing attorney of U.S. Market Advisors Law Group. It is a firm that does security litigation in the U.S., primarily represent institutional investors. And through that work, I've also done some transactional work for institutional investors and folks in the legal services space. One of my major clients is Batea. So thanks, Batea. I'm an external counsel for Batea, and then also I'm counsel for ISAF Management Company, which is a litigation funding servicer, which Adam knows a little bit about. He'll tell you about as well. So good to be here. Good to see everyone, and I'll hand it over to you, Adam.
Sure. Adam Folk. I'm with ISAF Management Company. So ISAF is the abbreviation for International Securities Associations and Foundations Management Company. So ISAF is much less of a mouthful, so that's what we call it, ISAF Management Company. We've been, our first litigation, which we'll touch more on, we started back in 2015, was against Volkswagen related to the Dieselgate scandal. We represent institutional, professional investors. And then we, soon after that, started a case against Petrobras. We can go more into that later as well. And then our last case in our portfolio at this point is the Danske Bank case relating to money laundering scandal uncovered back in 2017. So we have we take a very small, we have a small portfolio, but we have a very hands-on approach to not only obviously funding, but providing administration through the litigation, as well as finding the lawyers, working with the lawyers in various jurisdictions. So that's kind of what ISAP does.
So if you wanted to kind of expound on that, Adam, maybe talking more about funding, kind of finding financial resources of sourcing a plaintiff for a case and a little bit more. How does that work?
Oh, I mean, for us, it's less about the financial resources. We have resources that we tap into as needed. Many of the principals are successful of ISAP, or successful businessmen and women in their own right, and have taken an approach to investing in, I guess, would be considered non-correlated type strategy. But obviously takes a high level of understanding and knowledge about not only litigation and representing investors in securities litigation and antitrust litigation, but also having relationships with lawyers, so with boots on the ground in various jurisdictions. So once we have kind of a general comfort level with that, the financing, is not something that we create a budget and we try to figure out what the resources will be. Obviously, you don't know for sure, but we have a range in mind, and it's more about what it quickly focuses more to, like, is this a meritorious case? Is it something that we want to spend 6, 7, hopefully not 8 years doing and funding? and you know, how do we build the book, so to speak, and what else is going on against this either defendant or a group of defendants that we need to be worried about, concerned about as we proceed, you know, down the road in litigation.
So I think we'll turn over to David. I mean, looking at you know, the investors and the organization behind the funds of file, how exactly would you go about choosing that? I mean, you know, for finding a foreign local counsel.
Yeah, I mean, it's tough sometimes when you can see internationally a country may have changed their laws recently where class actions or collective actions are now available, and or perhaps it's shareholder rights or laws or something new the legislature just passed. You may not know anyone in that country. So, and then, for example, we're litigating in Denmark. I mean, Denmark is the same population as South Carolina, roughly. And a lot of the law firms there, they like to represent corporate clients because they pay and it's an ongoing gig as opposed to a shareholder action, which there's not a lot of publicly traded companies in Denmark. And so the plaintiff side case may be there for a short while, then be gone. And so a law firm may not want that conflict. So it does take some due diligence. It takes traveling to the country. It takes knowing folks there. It is just like, I'm sure some of you, when you're not barred or in a certain jurisdiction, you want to be pro hoc in, you want to file with local counsel somewhere, there is sometimes a little bit of an interview process and just finding out who you want to work with or who kind of has the most juice, as my mentor used to say. And so there is a lot of that. It's just trying to make sure you have the right mix of both the litigation funder who is willing to take that risk, and then also local counsel who is experienced or reputable enough to pursue a case. And often you might have to look for kind of like parallel experience where there's a country we're looking at now for possible litigation, and there's literally been one major securities case. And so there's not a whole lot you can go on, but if you think everything else about the case is right, you at some point you just have to take that calculated risk. And so, so I think that's, you know, there's no formula to it. It's just a lot of just digging in and doing your due diligence.
But procedurally, I mean, there's big differences once you know, left the U.S., North Americas.
Right, and you know, a lot, and does anyone litigate outside the U.S.? I'm assuming that no one here. Okay, so you do. What countries or types of cases?
I don't currently have anything. We have a matter of Germany.
Okay, great. Yeah, we may talk about Volkswagen here in a minute. Well, and you know, one driver of these cases where, you know, U.S. attorneys or litigation funders might get involved is there are not contingency fees available in certain types of cases. So lawyers literally can't get contingency fees. So it just changes the dynamics of how a case is funded. Shareholders generally, because they're used to the U.S. system, they don't want to pay for this type of litigation. So it does create the need for a third party to help offset some of that risk and cost. Is that
Yeah, I think just, you know, and then maybe turning to Adam for the financial perspective of, you know, how do others get paid, you know, outside of the U.S. system, you know, looking at lawyers, advisors.
Well, that's an important question, obviously. But it varies by jurisdiction, as David just touched on. But I mean, just broadly, you know, there's some jurisdictions that lawyers can work at least partly on contingency, but they don't generally want to, because that's just not the model that they, you know, there's in their country. And So that kind of gives rise for the need for litigation, a third-party litigation funder. I should have mentioned this earlier, but we're probably not you guys typical. We're much more of a niche litigation funder. We're not a large public company like Burford or former Bentham groups and others. I mean, there's a lot of money out there doing litigation funding. We're not that. We take a very niche approach and fund do a lot of the way that we contain costs are by doing a lot of the work ourselves, and that's a lot of financial analysis, market analysis, working with the law firms that we work with to do to the best of our ability or help them with the legal analysis and the jurisdiction, especially related to how damages can be pled. Given that, I mean, I'm not talking about the litigation funding kind of in general, because there are different ways to do it. Some larger companies actually buy kind of portfolios of, well, David can talk more about it, but cases basically, and hundreds of cases, and they raise a fund and work with a law firm, and they'll have $10 million advance to that law firm, and hopefully that yields some return on their investment. For us, we're taking a much more concentrated position in these specific cases for the reasons I just mentioned. We're much more able to help control the costs and the expenses and create a higher return for us. As far as how lawyers get paid, for the most part, it's hourly. We manage the expenses. We require the law firms that we work with in various jurisdictions to provide budgets in advance, and then we try and keep them to it. Obviously, you can't plan for everything, but and then there's obviously, as you get further along in different parts of the litigation or phases of it, you're working with experts, whether it's other law firms or other professors in various jurisdictions that can opine on certain parts of the cases, whatever stage you're in. And then obviously there's a lot of management from the client side, and that's we do all of that. We're the kind of the face of the litigation as far as the investor who lost money is concerned. I call them clients, but that's kind of how it works. And then if there's a resolution to the case, how do the clients get paid? There's typically it'll be either a settlement fund is established and a claims administrator, similar, and probably the claims administrator that everyone here is probably familiar with, one of them would be hired to manage and administer the settlement fund. And obviously we had in the 3 cases we're actively involved in, we haven't gotten to that point yet. I'm hoping soon, but if there's no settlement, we go, obviously are prepared, and we'll go all the way, and depending on the jurisdiction, it's more costs involved, obviously, that you're litigating for damages individually for each of the clients, and the client gets paid as a percentage, of whatever they lost usually. So, and if you're litigating for damages directly, you would think, I'm sure, and you will get a higher percentage of losses.
So I think, with some of the generalities that we've walked through so far, participating outside of the U.S., we're getting a little bit more specific on some of the actual litigation examples. So could you maybe speak to some of the foreign jurisdictions? I mean, certainly, from a filing perspective, the TSCs, there's a very large difference, but I wondered if maybe we could get into, what's happening maybe over in the Netherlands.
Yeah, and I think David can chip in as here, because he's been very involved in all this. But so in the Netherlands, we took a novel approach, not only to how we started the case against Petrobras. Petrobras, as you know, is a Brazilian company, so why did we sue them in the Netherlands? Well, we didn't start thinking we were going to sue them in the Netherlands. We obviously looked at Brazil, quickly came to the realization that wasn't going to do anything. The field was heavily stacked against you. In fact, if you went the class action or collective route in Brazil, you basically would start it and then petition, I guess the equivalent of a state prosecutor to take the case over. So that's just how their class action system works. Other groups, funding groups, went in and went the arbitration route, which we didn't like either. At the time, the president of Brazil, the president of Petrobras, was also on the board of the market chamber, the VESPA, now the B3. And that's where the arbitration hearing would be heard. And obviously, Petrobras being a state-owned company and the VESPA being a state-owned company, we felt like it would be not a good situation to be in a lot of conflict. So we started looking at other areas and realized quickly, and this kind of is the benefit of having people who have a lot of financial market experience, many years, decades of how transactional analysis, market making, just financial markets in general. We realized that Petrobras, I forget what year it was, but early 2000s or 2004 or something, had created a listing in Spain on an index called the Latibex, which traded on the Bolsa Madrid, and was a group of, I think, 12 or 15 companies, big companies in South America or Latin America. And so that created a legal nexus. These shares were basically, they weren't like ADRs, they were actually tracking shares. And so when you bought a share on the Bolsa Madrid of Petrobras, it was actually a one-for-one, an exact link to the Brazilian market. Unlike what was going on in the ADRs, which I'm sure everyone's familiar with, what an ADR, ADS system in the US. So we went down the road of looking at litigating in Spain, which you can organize collective actions in Spain. It is somewhat of a foundation model. It's actually it's a shareholder association model, and yet there are certain things you have to, boxes you have to check to be able to do it, and we did that. We had investors backing it, and we'd be stepping up to join a group of investors. But we also realized that Petrobras was doing a lot of the marketing for their securities outside of Spain from their financial headquarters, really, in Rotterdam. And they had a lot of nexus to Rotterdam in the Netherlands, not only operationally, but that was where Petrobras Global Finance was in various subsidiaries where they marketed bonds and sold a lot of, they were the most indebted company in the world at one point. And people were eating up their bonds all over the world. And but a lot of that activity was happening in the Netherlands, and we had some experience in the Netherlands and had some good law firms that we had worked with in the past, and realized that we could basically take a novel approach to suing Petrobras in a collective action by hiring or basically working with a shareholder foundation, which is a board of respected and experienced individuals, judges, politicians, things like that, and they would act as sort of the lead plaintiff representing investors who were impacted by the Petrobras scandal, which was basically kickbacks and briberies to fund the Labor Party, for a number of years, decade. And also another nexus to the Netherlands was that the largest foreign or the largest bribery and corruption fine ever at that point in the Netherlands was a company that Petrobras was in the Petrobras kind of cartel called SBM Offshore, and they were funneling kickbacks through African subsidiaries through the Netherlands back to Brazil. So we established the nexus, and we had a thesis on the standing of the shareholders in the Netherlands, and 6 years later we're at the point where we've gone through a lot of we've gotten to the point where we're now we'll be having hearings on the merits either by the end of this year or beginning 2023. That's kind of the final stage of whether Petrobras wants to settle, as they did in the U.S. with the ADR investors, or they get sued for direct damages by all the shareholders plus interest, for the whatever 8-9 years that we've been involved in. So I don't know, David, if you want to talk more about the foundation model, or maybe the WCAM system.
Yeah, I just think it's interesting to point out that, as opposed to a class action in the U.S., this is not a class action. It's essentially a legal entity that's formed in order to litigate on behalf of investors who are harmed. And the investors, they can sign up and participate and be part of the group. But essentially all they're doing at this stage and have for the last 6 years is they wrote letters of support saying we support this foundation, and we believe in the merits, and that if there is some type of resolution, we support whatever that is. And so in terms of procedurally, there's no discovery. There has been no real discovery involved really on either side. In a lot of these cases, you get zero discovery from the corporate actor or the defendant. And so there's very little work, so to speak, that has to be done on the plaintiff side. Essentially, they provide records to the organizer, the litigation funder, whoever that is, showing that they can evidence they traded during a relevant period and were harmed. And apart from that, there's not a whole lot to do. And in some respects, it's if there is a successful outcome, it's like a class action settlement on the end of it, where something's already happened by other parties out there, and you essentially just sign up at the end and collect your money. And that is that foundation model in the Netherlands is interesting, but it's also very different. Kind of where we're going to other cases. In other countries, there is class action law, and it's relatively new, but a lot of the class actions you hear about overseas aren't really class actions. They're collective actions where essentially you're suing the company directly, but your law firm has organized a bunch of investors to also sue at the same time. And so it's essentially an opt-in system versus here it's an opt-out system. And that also facilitates the need for organizers, litigation funders, someone to step in and say this case is worth pursuing, but not for just one shareholder. Someone or some entity needs to step in and do something in order for this case to be successful, in order for it to be economical. And so that's why you see litigation funders going overseas, because one, it can be lucrative, but two, there's a void there that the law firms that are local aren't either necessarily equipped to handle, or just that's really never been part of the practice group. And so just jumping right into kind of a difference in Germany, ISAF, which I'm counsel for, has a case against Volkswagen, and I'm sure, or I would be surprised if you hadn't heard of the Dieselgate scandal that came out a few years ago, essentially where the Volkswagen cars had cheat systems on there where it essentially made their emissions look better than they actually were. And it was a huge scandal. There's been a lot of litigation in the US over it. And there's been various outcomes depending on the defendant. But as I'm sure everyone can guess, Volkswagen is headquartered in Germany. Volkswagen shares trade on Frankfurt primarily. That's where most of the float's at. So for those reasons, especially when you have institutional investors that can trade anywhere now if you're large enough size, it made sense to file in Germany, which had, at least a few years ago, pretty plaintiff-friendly laws where essentially if you wanted to participate in a collective action, you essentially sign up, you register, and then the case is litigated, and then you file a claim at the end. And a couple years ago, unfortunately, during the middle of our case, after a lot of institutional investors had signed up, the law changed. There was a Supreme Court ruling that essentially said all of these investors who have registered these various different groups, you need to prove standing and authority issues in order for you to move on. And in Germany, there's something somewhat like an NDL system. It's kind of a consolidation system where a higher court will take all the different groups and essentially appoint a lead counsel or a lead plaintiff and litigate the different, I guess, the important merits of the case. And so investors were, so to speak, kind of just tagging along with that. And then when the law changed, they had to essentially prove standing issues, which, did you have the authority to file this claim? Did you really trade during this time that you said you did? Are you who you say you are? And it's very interesting because in the US, most plaintiffs are very passive unless you're a representative. And two, something that needed a lot of litigation help it's just fascinating. You had several hundred institutional investors, and all of a sudden they have to produce all this documentation because they are literally suing. They are not part of some just claims filing process. They are named plaintiffs in a collective action, and the Volkswagen, their attorneys, did a good job in kind of using the change in the law to say we are going to try to limit this claim as much as possible. Arguably there's very good merits, and Volkswagen has admitted to certain things, but we don't care. We're going to make you prove standing, which arguably you would say they should. That's their right, in a way to just kind of limit and prolong the case. And so that was very interesting for us, and kind of a very, very difficult thing to get through because while they were, I guess you could talk about client expectations here. While a client might expect just to file some paperwork, they were actually essentially put in a position where you might see a lead plaintiff have to operate in the US, where they actually have to do a little bit more than just essentially show up. So that case, has had some good rulings, and we're still optimistic about it, but that certainly is a setback, and it's just kind of reinforces the point made earlier about these foreign countries that are relatively new. Our securities laws started in the 30s, whereas a lot of times their securities laws and class action law, it's 2000 something, 2015 Capital Markets Act. And so you can just imagine when laws are that new, it's going to take some time to figure it out, and there's not a whole lot of court guidance when there's no precedent. And so certainly interesting way to do it, and that collective action model I think is not as preferable as the foundation model, but it's, if you want to litigate in a country, that's sometimes what you're stuck with.
And I would just add that with our experience with Volkswagen, pretty much everything that we'll do going forward is kind of hold everything to the German standard.
Yeah, you can survive in Germany, you can survive anywhere.
To shift to another, different direct collective action, maybe you could give an update as to what's happening with the Danske Bank case in Denmark.
Yeah, I'll jump in. So Danske Bank is Denmark's largest bank, and you may have read or heard about a few years ago. They were part of the largest money laundering scandal in the history of the world. In early 2000s, they bought a bank and made it a branch in Estonia, and over time, it is alleged that maybe more than $200 billion in illicit funds funneled from places like Russia, from Russian mafia or mobsters or bad actors, I would argue, through this Estonian bank and then on to other places to support some very bad things or just to hide money. And so it was a huge scandal. It still is. Interestingly, just last week, Danske Bank announced that they are going to announce a possible settlement with Danish authorities, financial authorities, and the Department of Justice here in the US. So we may actually have some interesting news soon on that. But as you can imagine, this is kind of, as one Danish person told me, the crown of Denmark is kind of the most respectable financial services company in Denmark, and for this scandal to happen was certainly a black eye. But there was obvious harm to investors there. The stock price declined over 50% in a very short period of time. There's kind of there was whistleblowers, very clear signs that there had been wrongdoing. There was actually like some scandalous murder or alleged suicide.
No one to deal with the FSB and food.
So it's an exciting case nonetheless, but it is another one of those direct action cases where there's competing groups out there. Organizers, funders will try to collect or build a book, as some folks say, of investors who want to participate, and essentially they file a claim, and because there's no great consolidation laws and not a lot of precedent, essentially what happened is different groups filed in different courts, and the higher court decided essentially to pull some test cases and make those cases determinative of certain issues on the merits, and then the rest of the cases would be stayed until there was an outcome there. And so that's kind of where we are with those cases. There are a few plaintiffs that are moving along and deciding things. And unfortunately, if you're not part of that group, you just kind of have to wait just to see what the outcome is. And there you can't petition to be part of the larger group. And there's certainly been some cooperation among plaintiff law firms to try to find the best way forward. And there's been some sharing of resources. But there's not a lot of method to the madness. The court just decided that we were going to move forward with certain test cases. If you're not part of the group, then you just have to wait around. So that's where we're at on that. And I don't know what else.
I mean, I think you bring up a good point. I think it's pretty typical, at least in all the cases that we're involved in. I mean, we coordinate pretty closely with almost all of the coalitions, if you want to call it that, funding coalitions, and there's even overlap if some of these groups have more institutional type funding behind them, and they're invested in many of the same cases that we are. I mean, we're just different, as I said, a different type of funding organization. But one of the things that we have and we do is, we provide a lot of research and have a lot of experience, as I said, in capital market and transaction analysis, damage analyses, things like that. And so we've been pretty instrumental. I think you can ask any of our competitors, but at some point, you're not a competitor. When the book's been built and the statute of limitations is passed, you're all on the same side, and you all want the result. So that we're pretty, especially in Danske Bank, we've been very active, and more so now in Volkswagen, and even a little bit in Petrobras, even though we're the only group out there in the Netherlands that has had as much kind of success and development, pursuing a case against Petrobras, but we are working with others and have talked to other groups that are in Brazil, and it is an interesting business because at first you're out there competing for the buck. This David probably doesn't like that term, the lawyer, from you're coming from more of the market side, that's what it is, I think. But then it's when the statute runs and it's you're just all going for the same thing, so we cooperate quite a bit.
To move to another emerging market, looking towards Australia. Obviously, we say as clients and we'll be filing in those cases, but maybe both of you, either of you, can talk a little bit about how they work, how those kind of differ from those in the U.S.
I'll let David take it because I can tell you from a funding perspective, not interested.
The interesting thing about Australia is you really need to set up shop there, and there's actually some law that would kind of prohibit you from funding a case outside the U.S. I'm not going to go into that more here. So essentially, you need to be in Australia. Arguably, it's helpful to be anywhere on the ground where you're filing a case. But so Australia is interesting because I don't know if folks there would like the comparison, but in a lot of ways they copy the U.S. model. At least from afar, you would think that they copied the U.S. model, and it is probably the most active place outside of the U.S. for securities class actions, or maybe consumer and securities class actions together. I saw a report for, I think, Institutional Shareholder Services that last year, I think over $1 billion in funds were recovered in just securities cases in Australia, so 2020, 2021. So I mean, that's money, that's decent money there. And so a few years ago, with changes essentially in class action law in the early 90s, it made it more easier to file a case there. And so a lot of litigation funders set up, and it allowed what would be traditionally just a few firms to handle these type cases to allow smaller law firms to funding the capital to pursue, be more aggressive with these cases. And also just to change the laws generally, I think there was the government was kind of more friendly towards plaintiff-style class actions a few years ago. And the pendulum has definitely switched in the last few years. And so it just set up this kind of interesting event where they just developed almost overnight, just from afar, again, my perspective, a whole class action system. The interesting thing, though, there is just like our different states, the different states of Australia have different rules. And so, for example, Victoria state in Australia allows contingency fees, but no other state in Australia, at least last time I checked, does. And so you can see how when a court allows for that in a certain state, where are all the cases going to be filed? Well, I mean, they're probably all going to be filed in Victoria, especially if you're a law firm that doesn't like the competition of litigation funders. So you've got the capital to do it yourself. So the last few years it's kind of been, at least my experience, like an existential crisis for Australia, because they did have great plaintiff-friendly class action law, and now that pendulum is just shifting back towards just reining things in. And it's causing a lot of disruption. And from a client perspective, institutional investors, they want to file claims there. They want to get their money for these types of frauds. But what you're seeing now is just confusion because there is competition. They don't necessarily know who to go with. Do I go with a litigation funder? Do I go with just a traditional law firm who's, no fee if I don't, unless I win type of situation? And with that kind of competition, on top of the fact in Australia, there's no real consolidation law there. And so that means that you may choose someone or a group and it may not work out. You may be stayed. The good thing though is you can essentially fire counsel or unregister and go with the group if it looks like they're going to get a certain result. So so Australia is definitely something to watch. It seems like the rules for investors, even their participation agreements and contracts they sign are constantly changing. And until I think there's more stability in how the government views these type cases and how they want to handle contingency fees and litigation funders, there's just going to be a lot of chaos until all that stuff pans out.
Nothing else to add, Alan?
No, not interested, still not interested.
I think we can kind of round out the session just by talking about some of the investor expectations, important considerations, things for investors to keep in mind if they wish to participate. Obviously the U.S. has been traditionally, I think, the biggest, the most active jurisdiction. But could you summarize maybe where some of the issues to consider when you go outside of that area when it comes to book building or signing up an investment to participate?
It's really not about us. It's about what happens when there's a fraud or it's some sort of market manipulation that looks like it's right for an antitrust or for a securities fraud case. For us, we have tremendous access. Using the book building, but tremendous access to clients basically through our network, and we've been in business for a while, and Battea has been in business for even longer, although there's not really an affiliation specifically with Battea and ISAP, but there's a coalition type approach, and Battea's clients are well aware of any new cases that ISAP looks at, and we look at things. I think the jurisdictions we've been focused on are the ones that we're in, and the ones that we've kind of turned down for one reason or another. But there's who knows, there could be a case tomorrow. Typically these things start with an article in the Financial Times typically, or the Wall Street Journal or whatever, and it's could be weeks or months of kind of, well, what does this look like? How does it impact our network of potentially, how does it potentially impact our network of investors, and should we go out and ask them for specific data, and should we analyze, we do a lot of research at the outset to figure out, how the class, should be kind of formulated, as far as damages should be formulated, as well as time, the class period. And then, so that's kind of, I guess that kind of addresses your question. We'll look at any jurisdiction. Like I said, we looked at Australia and we're not interested, but we haven't done anything in Switzerland, but I've seen some things come up in Switzerland, and I know you can do it. And from a firm that David and I worked at before, we looked at things in France as well, and so there's a capability for investors to group together in France. Obviously, we talked about Germany, we talked about the foundation model in the Netherlands, which we like, but then there's other ways to do things in the Netherlands as well, more settlement focused. Their class action settlement law called the VCAM or WCAM, WCAM as an American calls it. I don't know if anyone remembers the Royal Dutch Shell settlement back in 2000 7, yeah, so that was set up as it was an elegant solution, at the time for Royal Dutch Shell, to basically compensate investors and have, a global release, and I think there was the same thing, it was relatively new at that point, so there were some things that people had problems with, but as I said, the Petrobras, the foundation model we're kind of working on now is a bit different because it's actually, the foundation is an actual litigant and it's not the thing, it wasn't set up as a settlement foundation where obviously both sides have to agree to settle. And I think that happened with Steinhoff, I think recently, we weren't involved in that case, but so yeah, we look at jurisdictions. We first do the analysis and the research on whether the case has merits. Then we look at the float, the transaction, who owns the company and how they were impacted. Then we do a deep dive in jurisdiction and figure out who we know in those jurisdictions and interview law firms and things like that. I don't know if Dave's got that.
Well, just from the kind of client perspective, that you all work in class action, and so you may think it's not very efficient, but I think globally the U.S. class action system is efficient, and a lot of that is because there's certainty. And so with institutional investors who are used to that, who file claims rather passively, maybe whenever there's a settlement, they have this expectation of it being relatively easy. I mean, that's the whole purpose of administrators. Everyone works hard on that. And so when you tell someone you have to sue, like not someone else, not a rep, like you have to sue, it's a different calculus, it's a different expectation. And unfortunately, though, in a lot of these jurisdictions, you cannot be passive unless you actively do something. You will never get a recovery. And that's not to say that when you file as a named claimant that you have all these discovery obligations as you have in the US. Most of the time it's not true, but you do have to be active. So I think that's a lot of part of it. It's just the client really needs to understand the differences in what their expectations should be. And as a turnout, I don't want to tell the client, I don't know, but a lot of times you don't know, because sometimes literally the law hasn't been established enough for you to have some certainty around a matter. But if a client is understanding of kind of the risk there, which generally is never a financial risk thanks to litigation funders and how the case is structured, if they're kind of maybe reputational risk, which is generally not much at all, or the time commitment of getting their paperwork together, it can be very rewarding for them in terms of getting found money or some type of recovery. Just like I told you, Australia, there's $1 billion every year now, and in other jurisdictions are slowly starting to see some settlements where, like I mentioned, the Steinhoff case, which is South Africa and the Netherlands, that has a 500 million, give or take, size settlement, if not more, available. So I mean, it's definitely worth clients pursuing. But it's just they need to go into like a clear understanding that it's not quite like the U.S.
Very good. Thank you both. Are there any questions?
Yeah.
Okay.
Go ahead.
Any thoughts on the paradigm in the UK and the landscape for collective actions in the UK and the requirements for after the event insurance? Any thoughts on that?
Yeah, so I mean, I know Batea has looked at that very closely because of, I guess that was the RBS. It would look like clients, there was going to be a put on the investors, right? So that was scary, but that didn't happen. But ISAP itself is not involved in a case in the UK right now, but I think, from our perspective, it seems like it may be the securities type fraud case is less interesting to us right now than an antitrust case because of the issues that you mentioned. I think the loser pay type bond that you have to put up, and the put that the client's going to eventually face. And obviously, through Batea and U.S. Market Advisors and ISAP to some degree, we've had quite a bit of experience with some of these antitrust matters, market manipulation matters. So we would be pretty comfortable doing some deep dive analysis and figuring out if we were going to get involved. I think in a case on that level in the UK. So.
Yeah, we historically there's been some risk there that none of us I think were willing to take, and so it's but I think things are changing. Just kind of agree with Adam's sentiment there. Do you have questions?
Yeah, could you talk a little bit more, Adam, maybe about the ecosystem using Petrobras as an example? Do you end up having to take into account where other financing firms, other funding firms have filed? You're in the Netherlands, others maybe other places, and do you kind of sort yourselves based on the size of that potential damage class that you represent? Is that a major sorting factor? Is it ease of litigation in a particular jurisdiction you happen to be in? Are you necessarily going to work in some sort of coordinated way, or is there a big competition built in the beginning to get investors and then it calms down?
Yeah, you definitely hit on some very excellent and insightful points. But yeah, from my perspective and our perspective, I think the initial once you decided to go in, do it. Then it is the size. It is the group. The investors that are supporting you, and a lot. And we've been doing this for a while now. And a lot of when you're dealing with very sophisticated investors like all the guys that like little blocks down here, whatever, all around the place here. A lot of it will come down to cost. What the fee, the contingency fee is for the funder. A lot of it will come down to the insurance issues, like how depending on the jurisdiction, how are you going to finance the risk, so it doesn't get put, to the beneficial owner if something goes wrong, and so that there's definitely an analysis from the client perspective on that. And then, and some groups that have more experience, maybe we're like I said, we were kind of unknown when we first got into this, but we were competing with the likes of Quinn Emanuel, like very large law firms, global law firms that were doing this, and then in addition to like the large funders, like the publicly traded funders and some other smaller groups that had much more experience than us. We kind of came into it because we had, we had some niche experience and understanding of the jurisdiction or the case or whatever. But I think to answer your question, and I know it went around a little bit, but a lot of it comes down to the size of the group. And then in some cases, there can be a combination even before that happens. We've seen that happen, before there's an ultimate statute that runs, and then you're all getting together anyway. But there's and as far as who gets to lead the action, typically, at least in our experience, it is usually the group that has the largest group, like whether it's damages or number of clients, involved in the, in the group. So that's kind of the best answer I could give, I guess.
Any other questions?
Is there any capacity or for that matter, interest in bringing sort of the retail investors into some of these European cases?
Yeah, I mean Petrobras. We actually have a bunch of retail investors in the Petrobras case. Just it's pretty easy to sign them up, and there's not really a lot of documentation that needs to happen. I know in Germany and Volkswagen, there is like a retail class. We're not involved in that. There is a retail group that's being represented in the so-called, as David called, the higher court, but they're part of this capital proceeding, and which is the merits. Merits and the damages are going to be argued. Danske Bank, I think we actually do have a handful of Danish, investors who felt, but they're large. We had to have a minimum threshold because it was a different model. We had to, you can't represent someone who has like $100,000 loss. It's got to be, quite a bit more to make it, just to pay the court fees and all that kind of stuff.
Right, yeah, especially the jurisdictions where there is more discovery involved, so to speak, to have an investor with, $1,000 loss and all those requirements that they have to provide. It's just, again, the folks I work with are relatively small compared to others. It's just not efficient to do that. The cost benefit analysis would say that retail investors are not, it's just not a group we can work with, but there's certainly avenues for them to get recoveries.
Great. Any last questions? Well, thank you very much.
Yeah,
Thank you, Adam.